organizing, on labor generally. We're going to try to make the case that you all should care about this, if you don't already. My name is Marion Crane. I'm a professor at the University of North Carolina School of Law, where I teach labor and employment law and have a couple of books on the subjects. I also direct the Center on Poverty, Work, and Opportunity, founded by Senator Edwards in 2005. He's no longer with us. As you know, he's moved on to other activities, and I am now the director of the center. This panel's focus is on these questions. What is the relationship between a progressive politics for social justice and a strong labor movement? What is the relationship between workers' interests in economic security through employment and the values of a just society? What about the relationship between collective bargaining and democracy? My job as moderator is to lay the framework for this panel very briefly and then let the panelists engage you. The purpose of the Act, when Congress first enacted it back in 1935, and we're talking here about the National Labor Relations Act, was to acknowledge the inequality of bargaining power between individual employees serving at the will of their masters and employers organized in the corporate form. Without a collective vehicle for organizing and for voice, the thinking was, Congress's thinking was, workers individually were generally powerless to negotiate wages, working conditions, or hours. Their options were basically to quit or to submit. And the lower in the hierarchy the worker was, the more constrained the worker was in ability to individually bargain. The Act was intended to balance the inequality of power so that workers had this collective right to organize and balance that against the corporate form of organization. Senator Wagner, the principal author of the Act, also advanced another justification for the statute. He railed against the fundamental inconsistency between having a public politics of democracy and a workplace regime of totalitarianism. How could a people who were committed to democracy in the larger political sphere really believe in democracy if 8 or 9 hours a day in the workplace they were subject to a totalitarian regime? Said Wagner, "We must have democracy in industry as well as in government. Democracy in industry means fair participation by those who work in decisions vitally affecting their lives and livelihood." And he believed the way that should happen was through labor organizing into labor unions, which represented the majority of the employees in an appropriate unit for bargaining in every workplace where employees desired it. And the union would then negotiate with the employer a collective bargaining agreement, which would become the private law governing that workplace. The traditional paradigm of labor organizing was established then by the National Labor Relations Act. It essentially required employers, or essentially guaranteed to workers, the right to organize unions, the right to engage in protected concerted activity, group activity for mutual aid or protection, and the right to collectively bargain through a majority representative. The way in which these rights were realized was through a traditional paradigm. We're talking about changing the paradigm. That makes no sense unless you understand what the traditional paradigm was and is. This is how it went, and sometimes still goes. A union organizing drive characterized by adversarial campaigning between employer on the one hand campaigning against union and the union on the other hand campaigning for union representation. This organizing campaign monitored essentially by the National Labor Relations Board, the entity charged with overseeing and enforcing the Act. Once the union is successful in obtaining a significant number of signatures from employees who are interested in possibly having a union, 30% is the current showing of interest, the board orders a secret ballot board-supervised election in the unit appropriate for bargaining, that is, a group of employees with common interests. Then the election is held, again under board supervision. If the union wins, the law imposes an obligation on the employer to bargain with the union in good faith over wages, hours, and working conditions until either a contract is signed or impasse is reached. So there's no obligation to reach a contract, but there is this obligation to bargain. If a contract is reached, it erects this system of industrial self-government that Senator Wagner envisioned, a private law for that workplace administered by arbitrators primarily, who function pursuant to the collective bargaining agreement's typical grievance administration processes. A lot has changed since 1935. Many of those changes are not legal. For example, the labor force has changed. Influx of women, increased racial and ethnic diversity, and an influx of immigrants, documented and undocumented. The labor market itself has changed. Dramatic growth in the service sector, shrinking of the industrial sector, where union density historically was strongest. The organization of work has changed. Technological advances have eroded historical geographical constraints on employers. So, for example, boundaries on product markets and on location of production have eroded. Unions themselves have changed, both in their structure, witness the split-off of the change to win unions the last couple of years, and in their praxis. They've moved away increasingly from traditional business unionism and are experimenting instead with corporate campaigns and industry-based organizing and other strategies that some of our speakers will talk about. Management human resources practices have become far more sophisticated, with both a rise in anti-union management consultant use befitting the adversarial system, and also a rise in prophylactic HR policies that are really directed at the burgeoning employment laws, separate from the labor laws, that have occurred. All of these forces, and probably some others as well, have contributed to a dramatic decline in labor union density. Labor union density has fallen to less than 8% of the private sector workforce and less than 12% of the overall workforce, including the public sector, where unions are generally stronger. If a vibrant labor movement is truly the foundation for a strong democracy, as Senator Wagner believed, and if we need a labor movement to balance the consolidated employer power and the individual employee powerlessness on the other hand, organizing somehow is key. How should the paradigm of labor organizing change? What role can or should the law play in changing this paradigm? Those are the questions that the panelists have been charged with answering. Let me give you a brief introduction of all of them and then let them go. Mary Beth Maxwell will be our first speaker. She's the founding executive director of the American Rights at Work organization, which is an advocacy organization launched in 2003 to advance workers' rights to organize and bargain. In its brief history, she's led the organization in exposing union busting in the New York Times and the Wall Street Journal, monitoring decisions of the board, and informing the policy debate on workers' freedom to form unions through original research studies. She's authored some of those herself. In all her work, she strives to place workers' rights more squarely on the progressive political agenda. Mary Beth will be followed by Portia Wu to her left, who is currently Senator Kennedy's Chief Labor and Pensions Counsel on the Health, Education, Labor, and Pensions Committee, and consequently has some very detailed knowledge of legislative initiatives that have gone forward in the recent past and that are planned for the future. Before her position as counsel to Senator Kennedy, she practiced law at Bredhoff and Kaiser, representing unions, pension plans, and workers, so you know what her perspective might be. Ben Sachs, to my immediate left, is the inaugural Joseph Goldstein Fellow at Yale Law School, so he's a law professor kind of in training, like I am, where he teaches labor law. He has authored a couple of articles, some very provocative works so far, and he'll be talking about some of the ideas in those articles, and was awarded the Yale Law School Teaching Award in 2007, so he's doing a good job there. Before he came to teaching, he was Assistant General Counsel for the Service Employees International Union in Washington, where some of you may know him from. Before joining the SEIU, he worked at Make the Road by Walking, a membership-based community organization in Brooklyn, New York, where he co-founded the Workplace Justice Project. And last but certainly not least, we will have Willis Goldsmith, who represents management in all phases of labor and employment law. and is chair, or was chair until 2006, of Jones Day's labor and employment practice. He now heads the firm's New York litigation practice. Much of his practice includes litigation and advice in connection with traditional labor law matters. He's an advisor to the ALI on its restatement of Law 3rd for employment law, so he's no stranger to employment law either. He's listed in the labor and employment law sections of the Best Lawyers in America, and was identified in the National Law Journal's Who's Who of Employment Labor Lawyers as one of the top 36 labor and employment lawyers in the country. Finally, he's a fellow of the College of Labor and Employment Lawyers and a member of the Labor Law Advisory Committee of the U.S. Chamber of Commerce. He's a graduate of Brown University and NYU Law School. So, without further ado, we're going to turn this over to Mary Beth Maxwell. She'll be our first speaker. Each speaker will speak for approximately 7-ish minutes, and then at the close of that, I'll prompt them with some questions, and finally we'll open it to you. Mary Beth.
Thanks very much, Marion, and thanks for all of you for being here this morning. Really excited that ACS is sponsoring this panel and having this conversation. You know, I think we're at a really exciting and interesting moment to be talking about paradigm change around labor organizing. And one of the reasons for that happening, and I think important context for it happening, is that we also have a very finally overdue awareness and conversation, national conversation happening around a rising income inequality in the United States and the impact that that has on working families, on our economy as a whole, and on our democracy. And I think that's a key part of the context for having this conversation. So finally, we have this long overdue conversation happening about income inequality. And increasingly, finally as well, you have folks acknowledging that one of the reasons for this huge rift now, the growing income inequality, is the decreasing number of workers that have union membership, that get to engage in collective bargaining, and the decrease in that bargaining power. And that's not just unions saying that now. It's Paul Krugman, it's even Bernanke, right, acknowledging that this is one of the reasons that we are seeing the kind of income inequality in the United States that we're seeing. I think it's important context for how this connects to the question of the role of this question in progressive politics. The question, you know, Marion refers to a number of different factors that have changed in the economy, in the workplace, right, that account for some of those decline in union density. But the big question, I think, is what, right, is why do so few workers have union membership now, right? And some of those factors that she refers to absolutely are a big part of that. But an assumption that happens is that workers don't have membership in unions now because they don't want it anymore and because they don't need it anymore. And I think that could not be further from the truth. The polling data indicates very, very strongly that workers know that if they have union membership, they have more of a voice around wages and benefits, and they want to have that voice. And that millions of workers, as many as 60 million workers, would really happily have union membership and have that voice in the workplace if they could. One of the big reasons that most people don't know, right, about why so few workers now have unions is that, number one, employer interference is off the charts. That when Marion kind of, you know, talks about how when the law was created, right, decades later now, you've got employer interference in workers' freedom to form unions that has just escalated astronomically. Illegal activity in the workplace, right, so that routinely workers are illegally harassed, intimidated, and even fired during the course of organizing campaigns. And that is one of the main reasons why it is so difficult for workers to form unions today. Research indicates that it's somewhere between 25 and 30% of organizing campaigns, someone is illegally fired in the course of that campaign. So employer interference off the charts. But secondly, a legal system, right, or a legal paradigm that completely fails to regulate that and to protect those workers' rights. So that when people are illegally fired, there's really no remedy, right? There's really no punishment for that. It can take years and years for a determination to be made if illegal activity happened in that case, and even when it does, the penalty to an employer for illegally firing someone during the course of a campaign is to pay back pay minus whatever a worker earned or should have earned in the meantime. So employers know, right, that it's a really meaningless penalty, and it's actually a fairly cost-effective way to just shut down an organizing campaign. The current legal system completely fails to deal with that. But the other failure of the current legal system, which is one of the main reasons why so few workers have unions today, is that it's gotten to the point by manipulating the ability with appeals and delays and all kinds of activity that is completely legal, employers don't even have to break the law, right, to run sophisticated campaigns counseled by union-busting consultants, frankly, to make it virtually impossible for workers to come together and express their collective voice. There's all kinds of, outrageous intimidation and harassment where, even if the employer is told they have to stop it, the only thing they're going to have to do now is put a posting up in the workplace that says, we won't do this again. Human Rights Watch just issued a new report taking a look at the labor practices of Walmart, right? It varies from year to year if it's the nation's largest employer or one of the nation's largest employers. Walmart does not, they do break the law, but they don't have to break the law, right, to maintain a union-free environment. They are absolutely violating people's rights and their human rights in the workplace every day. So our legal system is completely out of date with that. And I think one of the questions that Marion phrased of, why this or how this matters to progressive politics, which I think is really fascinating, is that I think folks in this room understand, I think, why that matters and how critical this is, right? But we have a lot of work to do with even folks in the progressive and liberal communities, right, to educate about why this matters, that it has become so difficult and virtually impossible for so many workers to form unions. It is very acceptable, even in progressive arenas, right, to maintain a union-busting kind of position. And this paradigm that we are in right now in terms of the social norms around union organizing did not come from nowhere. There's a very well-resourced, well-coordinated effort on the part of union-busting consultants, the Chamber of Commerce, and political organizations like Grover Norquist's political organizations that really, if they could, want to wipe unions off the face of the terrain. And are driving an agenda. This notion that we're in right now did not come from nowhere, right? It's been organized and resourced. And I think we've got to really talk concretely with progressives about that. The good news is that it really does not have to be this way, right? That there is incredibly exciting innovation happening. For starters, there's innovation happening in the private sector and even with employers. You look at examples like what was Singular Wireless is now AT&T, where the company made an agreement with the union to say, we are not going to lock ourselves into this conflict-ridden adversarial way to make a decision about whether or not workers can have a union here. We're going to engage, we're going to make an agreement together that workers are going to have a free and fair choice at Singular Wireless about whether or not they want to form a union, right? And we will sit down and come up with some fair rules together, which is exactly what they did. And in the course of a year, 17,000 workers at Singular Wireless, now AT&T, just had their own choice and chose to have union representation. Did all of them choose it? No, but the vast majority of them did. And the company's position was, if you do, it's up to you, then we'll sit down and bargain a contract and get about the business of running this really successful cell phone company. An interesting note on this Singular Wireless example, we did a forum here in Washington, D.C. with representatives from management and representatives from the union. And what Singular described was that in the quarter, right, in the quarter where the majority of workers were making a choice about whether or not they wanted to form a union, they did it through majority sign-up, not through an NLRB election. They had their highest profits in that quarter of the year. And what the management representative from Singular was saying was, we were not wasting company resources on a conflict with our own workers about whether or not they would form a union, right? Instead, management and workers were working together to provide the best cell phone service that we could, right? So that there are real advantages in the private sector and in those innovations to moving into a way away from this kind of conflict-ridden NLRB election process and working together and collaborating. Harley-Davidson would be another example that I would lift up, where here's an example of the company working with its workers and its union to say we can have free and fair choice about whether or not workers want to form a union, and we can work together to make changes in our company to keep good manufacturing jobs here in the United States. We can do that if we commit to working together in a new way. The other good news about why it doesn't have to be this way is that there is incredible momentum now around this new piece of legislation, the Employee Free Choice Act, that would say, let's look at this innovation that's happening with companies in the private sector and in the public sector with employers. And let's get labor law, our public policy, to catch up with a new policy that makes sense in a 21st century global economy. The Employee Free Choice Act would update and reform the NLRA to make it more possible for workers to form unions again, to make meaningful penalties when employers break the law, and to actually restore the promise of the Wagner Act that we value collective bargaining and value workers having a voice at work. There's incredible momentum behind this bill. It passed with a big bipartisan majority in the House. We did achieve majority status in the Senate as well, and both labor and opponents to the Employee Free Choice Act are very clear right now that this is just the beginning on the Employee Free Choice Act, and that there is really a gearing up for an even more aggressive campaign leading into 2009 around the Employee Free Choice Act, and finally bringing labor law up to date with a real commitment to protecting workers' rights and in a way that makes sense in a 21st century global economy. So I'll end there. Thanks.
Thank you. Portia.
Great. Thank you. Well, I wanted to start out, first I need to give my standard disclaimer. The views that I express today are my own. They are not the views of the Health Committee or Senator Kennedy, and if any of you out there is press or bloggers or whatever, you can't attribute anything I say here today. It's interesting that one of the key questions we want to address today is how does collective bargaining and organizing fit into a progressive political framework? Obviously, with the voting in of the 110th Congress, the turning of the House and the Senate to a Democratic majority, we came in with a broad Democratic agenda. And a lot of that agenda and a lot of the discussion in the campaigns last year was about this issue of economic insecurity. Americans felt that they were working longer and harder, that costs for everything, the basic costs of living, for gas, for housing, for food, for tuition, were going up faster than their incomes were. They're seeing a lot of wage stagnation. And so part of the agenda that Senator Kennedy and other Democrats came in with at the beginning of this Congress was to improve those conditions. In the Senate, we held a series of hearings actually on these issues, on economic insecurity and the middle class squeeze. And the first one was sort of a broad-ranging discussion of that. Obviously, a key issue on that slate was increasing the minimum wage, which has remained at $5.15 an hour for 10 years until this past week when we finally had the first step up of an increase. But another piece that we focused on in a hearing later in the spring was the decline in unionization and how that's affecting working men and women around the country. In the debate on the Employee Free Choice Act, which Mary Beth mentioned, the House took it up early in the year. In the Senate, that came to the floor in June of this year. And we had a number of days of debate while other bills were also on the floor as well. And it was very interesting to see the sorts of messages that resonated with members of Congress. We had about 20 members speak at different times about the bill and why it was important to them. And over again, I saw a couple of themes emerge. And by far, the most important to them was this problem of economic insecurity. And when we look back over the history of the last 60 or 70 years, in the American economy, the time at which we saw the highest rates of unionization was also the time when we saw the most even distribution of growth in income. So, for example, in the 50s and 60s, all quintiles of people, so from the lowest quintile to the highest quintile of people by incomes, were all rising. And in fact, the lower end of the spectrum, their real incomes increased more than people at the higher end. That effect decreased then over the 70s to 2000, and if you look since 2001, effectively everyone's real incomes have been falling except for the top 1% of incomes in America. So it's an incredibly stark contrast, and that's something that members of Congress and the public, I think, really understood as being an important nexus between unionization and shared prosperity, particularly for lower income and middle income people. we have, as Mary Beth mentioned, we have the Employee Free Choice Act. I'll just take a couple seconds to talk about that for those of you who haven't been following this legislation closely. There are a couple pieces to the legislation. One of them is to ensure that when workers use majority sign-up as a process, say, for example, by signing cards and saying they want to be recognize a certain union as their representative, that is recognized by the board. That there's sort of a long history about how this has been recognized in the past and an erosion of the recognition, but kind of simply put, that would be an alternative to secret ballot elections. I think one of the falsehoods that was permeated about the bill was that the bill somehow eliminated secret ballot elections for workers. That's absolutely not true. Workers could still use that route to select a union if they wanted to, but they also had this other alternative. So it's up to the workers in any given workplace to decide how they would want to choose a union if they want to do so. It also establishes processes to get to a first contract. This was something that we saw when we looked at the data, is a large portion of people who had chosen a union then never made it to a first contract. And that's very frustrating for everyone. It creates uncertainty for the employer. It's unfair to the workers who thought they were getting a deal, and then the negotiating gets bogged down, they get stalled, and there's no contract reached. A year or so later, the employer says, well, maybe you should decertify this union because you don't seem to have majority support, and if people are disaffected because they have no contract, there's a chance that will happen. It establishes a process that has been used in other countries and other contexts to say the parties, if they can't reach an agreement, go to a mediation process, and if that mediation process doesn't work, they go to arbitration. Obviously, at any time, if the parties say, well, let's keep working on this, I think we can get something together here, they're free to continue working together in that private process. And finally, as Mary Beth mentioned, it also creates enhanced penalties and provides for injunctive relief when workers' jobs are threatened. This was another problem that we saw, that the penalties are just not tough enough on the in current labor law. And so for a lot of employers, there is really not a high cost of violating the law. Workers may wait 3 to 5 years to get their jobs back by the time the case is finally processed through the National Labor Relations Board. And so that's not effective, and it has a real chilling effect on union activity. I do want to say that although a lot of the focus of this debate was on the problem of employer intimidation, it's important to recognize there are many employers who work in good faith in the system and work either with unionized workers or not. And also many employers, they don't want to see this become an adversarial system. And I think that's one of the problems, is they are caught in a situation where there is a race to the bottom because their competitors are hiring anti-union consultants. And then their lawyers are saying, well, if you don't do this, if you don't draw these hard lines, you're opening yourself up to these other problems. And so I think we felt that there was really a need to have a fundamental shift, and we don't see the Employee Free Choice Act as a major change, but it's making changes in some key areas that we think would benefit both workers and employers. Although that's the legislation that has gotten most of the focus in this area, there are some other pieces of legislation that Senator Kennedy and other members of Congress are working on in collective bargaining. One of them is the Public Safety Employees Collective Bargaining Act, and that actually passed the House very recently by a vote of 314 to 97. A majority of Republicans in the House voted for that, and that would provide a structure for public employees in different states to bargain and to bargain collectively. Okay, I'm supposed to wrap up now. I just want to say a few words at the end that we also have a bill about supervisors, and there are different ways in which the current National Labor Relations Board has sort of chipped away at the scope of people who can be recognized and bargain under the Act. And so there are many individual pieces of legislation to address those kinds of issues for graduate students or people in the construction industry or other issues like that. But really, this is only one arena in which Senator Kennedy and other Democrats feel that it's important to strengthen workers' hand, because unionization is about collective action. And there are a lot of other ways in which people need to come together and act for their collective good. So, increasing minimum labor standards, either through increasing the minimum wage or requiring paid sick days, since half of the people in the country don't have them, increasing their ability to join unions if they want to. other arenas in which workers are sort of losing their voice or don't have as strong a voice that I think still need to be explored are, for example, misclassification of workers. There are a lot of people in this country who are working under contract. They're not even being treated as employees. So they could never unionize, and also they're not, they may be working side by side with someone who's getting health and retirement benefits, and they are not. Another issue is in bankruptcy. We see increasing use of the bankruptcy process to sort of reorganize, and a lot of corporations are under pressure and they are shedding a lot of obligations in bankruptcy. That is very, very difficult for employees who may be unionized or may not be, who say, wait a second, I thought I had earned that pension. I thought I had that retiree health care promise or even just health care. And they're in a difficult position of having to trade off among these priorities for them. And also, the company and the court are trading off among other creditors. And so I think we're going to be looking at other ways to be sure workers, who are the key part of any industry, have a seat at the table, always have a seat at the table, and have real ability to work in part of that process. Workers always want to save their company. They want to save their jobs, too. And I think that's the last point I'd like to leave on, is that in the Senate we work on legislative frameworks. But at least at the current time, we have a very slim majority. We hope that majority will improve in the future. But it's always a process of compromise. And I think that's why it's important to keep an open dialogue and talk about how we can improve this system so that it works much better for workers, but also for employers, because in the end, I think what we have right now isn't functioning, and we need to find a way to make it do that.
Thank you. Ben.
Okay, so thanks. As we think about changing paradigms in labor organizing, and I think it's become clear from the first part of this session, the background is that we have a legal regime that no longer functions in a number of ways. And so one of the ways in which the legal regime no longer functions is that it does not seem to be able to protect and foster workers' efforts to organize and act collectively anymore. The Employee Free Choice Act is an important response to that failure. Right? And the legislation would correct some of the most profound problems with the statute. EFCA, though, comes after many years, decades really, of recognition that the federal law has this weakness, this flaw. So back in 1984, we had a House subcommittee report on the failure of U.S. labor law. And despite a number of important efforts to amend the statute, we haven't really managed any significant change for half a century. The NLRA's failure constitutes what we can think of as a blockage of the traditional legal channel for organizing and collective action. But workers and unions have not been content to wait for a federal legislative fix. And so what we have instead is something of a hydraulic effect in labor law, where the continuing demand for collective action and organization has forced open a number of alternative legal channels. Right? So the federal law remains blocked, but workers are unwilling to wait for a fix, and what we get is alternatives. And so with my few minutes, I want to lay out 3 alternative legal channels through which workers are now organizing. And this is, of course, not to deny the critical need for new federal legislation, but only to say that a lot of the dynamism out there in labor organizing and labor law is taking place outside of the confines of the National Labor Relations Act. Okay, so I'll do these very quickly. I have 5 minutes. I think that's 1 minute and 40 seconds per paradigm. All right. So the first alternative, and the one that'll be most familiar to us, is what we could call private ordering. Right? So Mary Beth actually touched on this. And that is that having grown increasingly frustrated with the National Labor Relations Act, unions are opting out of the federal legal regime and substituting private agreements bargained with employers for the NLRB's rules. So these agreements do 2 basic things. First, they set the ground rules for organizing campaigns. They govern, for example, what unions can say and what employers can say. And they offer a mechanism for determining at the end of the organizing campaign how employees are going to register their choice on the question of unionization. So let me just give you one example from Texas. where, for a number of reasons, union organizing has been a challenge historically. And yet, one of the most important organizing drives in the last decade took place recently in Houston when 5,000 janitors successfully unionized with SEIU. And this campaign was conducted entirely according to these kinds of private agreements. Right? So the union and Houston's 5 major cleaning contractors entered into an agreement where they explicitly agreed not to invoke the National Labor Relations Board's procedures. Instead, the employer agreed to take a neutral stance with respect to the employee's decision on unionization, and the union agreed not to take any economic action against the contractors during the organizing drive. The union also accepted what was called a collective bargaining trigger, agreeing not to demand bargaining with any contractor until it succeeded in organizing a majority of the Houston contractors, a majority of the market. This meant that no single employer in Houston would be placed at an economic disadvantage by union wage demands. Okay. And this agreement led to one of the largest organizing victories ever in the South. So some private organizing agreements, like the Houston Janitors Pact, are neutrality agreements. They bind the employer to stay out of the organizing process entirely and leave the decision to employees. But there's a great deal of variation in these agreements, and many, I suspect most, don't require employer neutrality. In some agreements, the content of employer speech is not limited, but the agreements pay attention in a way that the board has not to the context of speech, right, in order to limit its coercive potential. So, for example, some agreements prohibit so-called captive audience meetings, in which employees are compelled to listen to an employer message, while others forbid the employer from delivering anti-union messages through one-on-one meetings between supervisors and employees. Other agreements attempt to balance communicational opportunities by giving unions a chance to present their message to employees in a way that federal law does not. All right. So in addition to providing alternative rules for organizing campaigns, these agreements also substitute private procedures for determining what workers want when it comes to unionization. And here the most well-known device is the majority sign-up or card check, but there's variation here too. So some unions have relied on private election agreements in place of NLRB-conducted elections. And under those procedures, the employer and the union bring in a private election officer who conducts a secret ballot election according to the timelines and procedures established by the parties. So these agreements avoid the pitfalls inherent in board elections, right, while preserving a secret ballot. Now, there are important questions about this first alternative paradigm, which I hope we can get to in the question and answer. The primary one is, how do you get these agreements, right? And without getting into the details, what seems clear is that in all contexts, the union has to have some source of a priori power to secure a private organizing agreement. So this implies that unions that already have significant resources of one kind or another are much better positioned to get these kind of agreements, but it makes private ordering less of a potential alternative for smaller worker organizations. Okay. So in any event, private code of conduct and recognition agreements are one alternative paradigm for organizing. The second is state and local law, right? And here there are two strands worth noting. The first involves techniques of what we could call agglomeration, which is a term I borrow from Fred Feinstein. And here, states and localities agree to take on certain employer responsibilities for workers who otherwise have no employer with whom to bargain. So Portia was actually talking about some of these workers left out by the National Labor Relations Act. But states step in, right? And here the primary examples are in the sectors of home care and child care. In both sectors, although you have hundreds of thousands, really millions of workers doing the same work and being paid by the same funding streams, there's really rarely an employer. right? So home care work is performed often according to what we call an independent provider model, in which the worker's employer is the individual in whose home they work. And we have 2 million child care workers who provide care in their homes, classified as independent contractors. And in both settings, right, nearly impossible to organize and do collective bargaining. So enter state law. You have an increasing number of states that have enacted public authority laws through which the state takes some employment responsibility for the home care and child care workers who are paid by public funding streams. The workers then gain the right to organize and bargain collectively with the state as their employer. Okay. Hundreds of thousands of workers have unionized under these regimes of state law in recent years. In fact, the largest union organizing drive since 1937 occurred through this kind of channel, when 74,000 home care workers organized in LA. The wage gains, inconceivable in the absence of collective action, have been remarkable. California home care workers have bargained for wage gains of over 100%. All right. In addition to public authority legislation, states and localities are also intervening in the union organizing process through so-called neutrality laws and labor peace ordinances. Neutrality laws place limitations on what employers can do with state funds. So in California, for example, there's a law that prohibits employers from using state money to assist, promote, or deter union organizing. Okay. Now, note that these laws, despite their common name, don't actually require neutrality, right? And employers remain free to wage anti-union campaigns with private funds. But for employers who rely on state funding streams for a substantial portion of their operations, the strictures are highly significant. And as I'm running out of time, I'll just say that labor peace ordinances function in a slightly different manner. These are state and local laws that require employers who receive public monies to enter into agreements with labor unions that will eliminate the likelihood of labor unrest and service disruptions. Okay. So state and local law provides a second alternative set of channels for union organizing, but again, substantial limitations, right? The most obvious is that states and localities can attempt to innovate in labor law only when their own dollars are at stake. Right. Under the NLRA's preemption regime, at least as currently interpreted, local governments have no ability to intervene in purely private sector labor management relations. Okay. Lastly, a third and final alternative that I'll mention, it's clearly the most nascent one. I call it employment law as labor law, and we find this paradigm most frequently outside of the traditional union context. And here, instead of relying on the National Labor Relations Act to protect their organizing efforts, workers turn instead to the anti-retaliation provisions of employment laws like Title VII and the Fair Labor Standards Act. So to go quickly, where the National Labor Relations Act has weak remedies and no private right of action, under these statutes, workers are able to bring their own cases and win robust damages. There's a lot of promise here, also substantial limitations. Most significantly, workers can only organize under these statutes to secure rights granted by statute. Okay. So in very brief form, then, three alternative channels for labor organizing: private ordering, state and local law, and employment law. None of these constitutes a complete model of labor law or a comprehensive regime for organizing, but all of them respond to shortcomings in the current federal law, and all have provided alternative routes to organizing. Okay. Let me conclude just by bringing us back to the NLRA, because while these three channels are alternatives to that law, they all raise important questions about the future for federal labor law reform. First, the federal statute now stands as an impediment to the flourishing of these channels. Right? The board in recent years has taken steps that make organizing through private agreements more tenuous. And with respect to state and local law, federal preemption leaves very little room for innovation. So as we think about federal law reform, I would encourage us to engage with the question of whether the types of developments I've outlined are worth encouraging. And if they are, what that means in terms of amendments to the federal statute. Thanks.
Thank you. Willis, last but certainly not least.
Well, Thanks for inviting me. It's the second time I've been on a panel at this meeting. The last time was a couple of years ago, and I made a bet with myself as I got ready to come down from New York to Washington this morning that I could probably use the notes that I had prepared in connection with my last appearance here today, and I think I could have, which is in and of itself kind of an interesting observation. The title of the panel was slightly different, but the general thrust of the panel was very much the same. That is to say, there were 4 people on one side of the issue and me on the other. But more substantively, it did address questions and concerns about the direction of the labor movement in the United States. The title of the program, Changing Paradigm in Labor Organizing, obviously suggests that there's a problem in the labor organizing area, and that was touched upon really either directly or indirectly by all of my co-panelists. But before getting into the substance of what I'd like to say and how I'd like to respond, at least in part, to some of the things that were said, let me make a couple of statements up front. First of all, despite the fact that I've been a management labor lawyer for my entire professional life, which is 35 years, I sort of regret to say at this point, but I've had a great time doing it, and we'll have a great time doing it for a while longer. Despite my status as a management labor lawyer, I firmly believe in unions. I believe that they have served the country well. I believe they can serve the country well in the future. I believe very strongly in collective bargaining. I believe that employers and employees and unions have a shared interest in the economic vitality of the country, and that there are various ways of going about it. All of those groups, employers, employees, and individual employees, obviously have their own rights that need to be thought of and taken care of in the context of labor organizing. The second point I'd like to make is there are always in these panels, and I've been on a lot of them, not just the ACS meetings, there are always references to polls and pollsters and to organizations like Human Rights Watch and other organizations like that. I think a word to the wise is, why don't you read the polls for yourself? Read what Human Rights Watch says. Look at how the polls were conducted. Look at who the pollsters were. For every poll that tells you that the sky is falling, I can find a poll that says it's not. So I don't really pay any attention to those. One poll that you might look at that's actually fairly reliable, I suppose, is what actually happened in union elections in 2006, and that is that over 61% of the elections were won by unions. And while there's always this 25 to 30% number thrown around about the number of unlawful discharges, and I actually think I know the study that comes from, if you actually break down those statistics, the National Labor Relations Act statistics compiled by career people, not politicians, would tell you that the number of unlawful terminations during the course of organizing drives in 2005, perhaps 2006, was 2.7%. So you can take everything with a grain of salt, and I don't pay much attention to them. The third thing I'd like to say up front is that I personally don't accept the premise that the National Labor Relations Act is irreparably broken. Look, the National Labor Relations Act was a federal statute passed during the course of the Depression. It's a statute that, like all statutes, was passed by politicians. It represented a series of political compromises, as did the Taft-Hartley Act, as did every other employment statute that's been passed in this country. The degree to which the statutes are perceived as being broken or working is typically a function of who's in office at any given time. Hardly surprising, that's a function of our political system. I don't remember a panel like this being convened in connection with the Clinton board, which, if you look at the decision-making in that board, one could argue that it was as radical a departure from previous law as anything that has been said about the current board or the board in the Bush administration. So again, we're dealing with politics and politicians and compromises and lots of room for lots of things to happen. All right. I'll try to comment on a couple of things here, and somebody will keep me in line time-wise here. I guess I can take off my watch. if the premise is that labor organizing needs to be reassessed, and that labor unions and the way they begin to represent employees need to focus on how to change the paradigm. Marion mentioned a bunch of the reasons why there is a problem. One, the workforce is younger. The whole demographic problem is really number one. A younger workforce, more women, as was said, more immigrants, more part-timers, more people who are interested in being their own entrepreneurs and not really the kind of factory worker that was the basis for much of the debate surrounding the passage of the National Labor Relations Act. Another reason that there's a problem is that there's a history of poor results in the labor movement. Portia talked about economic insecurity. Well, I'd submit to you that you'll find no place in the country where there's more economic insecurity than Detroit. You're talking about the auto industry, the steel industry, the auto parts industry. And those were industries that were and are heavily organized. Those are industries that have been hurt perhaps irreparably by foreign competition. And there was nothing at the UAW or at the rubber workers before it was absorbed by the steel workers or any other union was able to stem. You could look at other industries as well for a history of poor results of collective bargaining, newspapers, for example. Globalization and how to deal with it. In order from the labor union's perspective, the paradigm to change, unions have to come up with a way to deal with the global economy, with the way that work can be done, not just in the United States or in a factory in a particular town in the United States, but anywhere. Certainly there are some tactical issues in connection with the current regime as far as labor organizing is concerned. That is to say, some labor organizers don't organize plants because they're bad at it. I've gone into plants myself, and I've been in many of them over the years, and I could walk in here and say, I could organize this place in 15 minutes. But, unions have tried and just can't. Maybe they're not very good at it. I think a key component, and this relates to both what Marion and Ben said, and that is that, employment law has changed things dramatically. You don't need a union, really, if you've got a hugely aggressive plaintiff's bar out there, which certainly exists. And the plaintiff's bar in the employment law context has certainly, in some respects, supplanted the need for unions. Company opposition? Yeah, of course there's company opposition to unions. Is it always unlawful, as the anecdotes would have you believe? Of course not. It is, of course, also true that there are rogue employers who act outside of the law, just like there are rogue unions who act outside of the law and rogue employees who act outside of the law. But I think the notion that every employer that is either non-union by choice or by chance is somehow that way because the employer acted unlawfully is just, frankly, silly. Now, let me point to a couple of examples of that. And there was there was a comment made about how in the context of progressive politics do you deal with the changing paradigm. I think Mary Beth referred to this. The entire tech sector, the most progressive employers, some would say, in the country, it's entirely non-union, not by accident. Microsoft, Bill Gates is not unsophisticated. He is not a stupid man. He understands what the economy does and how the economy works. And Microsoft has been non-union from the beginning. The CWA has tried to organize Microsoft through a group called WashTech for years. Now, you can say that Bill Gates is not progressive, that he's not a guy who understands the economy, but of course none of that is accurate. I could go on. Let me just briefly respond to the three paradigms that Ben mentioned. Private agreements, clearly something that is a wave of the future. But agreements are agreements. That is to say, they're reduced to words. And for every neutrality agreement that there is the potential for litigation under that neutrality agreement as to whether or not the terms have been complied with. And there are plenty of examples of that. and they're telling me my time's up, even though it was 3 against 1. My time's up. I should have negotiated. I should have negotiated for more time. That's that's a comment on my own skill. All right.
Well, I'm going to set you up, Willis, for the first to
I think
answer
I've already
the first
been
question.
set up, but that's okay.
Likely. Thank you. I have a couple of questions. I'm going to start with those, and then we'll turn it over to the audience to get the debate rolling. A number of you made the case, in fact, 3 of you made the case, that the NLRA is essentially dysfunctional. It certainly has ossified, as one prominent academic commentator has written, not having been amended in quite a number of years now, over half a century, despite vigorous efforts that we've heard described by many workers' side advocates and by the union movement. Should it be abolished? Commentators on both the left and the right have argued for this, including Rich Trumka and Richard Epstein, 2 opposing viewpoints. From the Trumka perspective, the reason to abolish it would be to make way for some of the state experimentation that both Mary Beth and Ben talked about. From the Epstein perspective, the market should be able to take care of this. What are your reactions to that? Should we abolish it? Want to start, Willis?
Well, from my perspective, no. I mean, I think it needs to be perhaps fine-tuned in certain ways. I don't know that the market answers everything, and I don't know that state and local initiatives, given the preemption regime, as Ben noted, can possibly carry the day in terms of the kinds of issues that the...
Well, if we abolished it, no more preemption. That's the point.
Well, that is true. That is true. But I think the likelihood of it being abolished is just, it's not going to happen. I mean, I'm not sure why it's, something that really ought to be debated, to be perfectly honest.
Mary Beth?
I mean, I think you wouldn't find a lot. I'm not surprised by Willis's response, because why would they call for abolishing a National Labor Relations Act, which it really works pretty well for your team, right? I do think that a notion of abolishing the act is more fitting in a political context if we feel like we cannot build enough public support and political power to make a better law, right? The best case scenario is that we actually have a law that really does reflect our values and maintain standards that we think are good for our economy and good for our democracy, right? And so if we're in a situation where we can actually build more public support and more political power to make a better law, I think that's the best case scenario. And that we talk about abolishing the National Labor Relations Act more in a situation of you think there is no hope of actually strengthening it in a meaningful way, and so you do at least need to get it out of the way because of the preemption issues for innovation.
Exactly. Portia, your thoughts?
Well, speaking just from the legislative perspective first, it's incredibly difficult to do something like that, is abolish something and have a complete overhaul. It's even more difficult than making small remedial changes. One thing that we looked at, speaking about this issue about the states versus the federal law, and particularly in a time when there are so many companies that operate in many states, I think it's difficult for them not to have a national regime to work under. But in the public safety collective bargaining context, legislation that's been moving through the House and Senate has a framework where it says, well, if the state has a law governing public employees bargaining that has these basic requirements, then they kind of go ahead with that law. If they don't, the Federal Labor Relations Authority sets up an alternative framework. And so you could, I guess one way to talk about this is changing, and Ben already talked about this, changing the existing law to allow more innovation, in the way we do with other labor standards. The federal law sets a floor. States can do more if they want to.
Ben?
My first observation is that the National Labor Relations Act is a huge statute that does a lot of things in addition to regulating labor organizing. So all we've talked about today is labor organizing. And it's a more complicated conversation, I think, than maybe we have time for. My sense is that you do need a federal labor law, that you need a federal baseline that essentially puts into practice principles on a federal level. So I would be opposed to getting rid of any federal protection for worker organizing and collective action. That's a federal principle that we need to remain committed to. Whether or not we could dramatically tailor the federal law so that it did that in a much better way than it does now, while fostering the kind of experimentation and innovation that we're seeing from state and local actors and from unions and management, that seems to me to be something worth pursuing.
So it sounds like, of course, that first question is a law professor's question. Not practical, not feasible, too many strong interests opposing that. But it gets things, it discloses underlying assumptions. So let me say what I heard. The NLRA has value principally in providing employment, of course, for labor and employment lawyers on both sides of the fence, and as a vehicle for establishing social norms, which at least it sounds like everyone on this panel is committed to the social norm of workers having a right to organize and to collectively bargain, albeit for different reasons. If that's the case, if that's really why we still have this statute as sort of a symbolic thing out there that tells us we have these rights, then the underlying issue is, are all these conversations and all this political activism about changing the labor law really just rearranging deck chairs on the Titanic? Is the law really the problem here, or do we need a larger paradigm shift in terms of our societal attitudes about collective action and organizing collectively for change? Is it fundamentally incompatible with the Horatio Alger myth, which is an individual kind of a myth, for people to join unions? If it is, then no amount of legal change will make a difference. What about that?
Yeah, I mean, it seems to me that we have really very good evidence that it's not contrary to that. I mean, hundreds of thousands of people, or millions of people, are continuing to join labor unions, and the demographic groups that Willis described as sort of constituting the new workforce, immigrant workers, people of color, are joining labor unions in huge numbers, right? So although we have union decline, we also have evidence of very, very vital and strong demand for organization. I would also say that I'm not that you intended this, but that the answer is to the question of is it law or is it social norms, right? Is both, and those things are implicated in each other. And I would say that a federal legal regime with such a weak remedial arsenal, right, is very related to a social norm that doesn't value these protections. And I think if we moved in a direction more like Title VII, right, where you had strong protections for the right to organize, that you'd see substantial effect from that.
Okay. Mary Beth?
Yeah, I mean, I think this speaks, that your question speaks to, a paradigm shift that I would say progressives need to make that may have nothing to do with, a legal paradigm, right? And that to observe that while on the more right-wing end of the political spectrum, Grover Norquist and the Chamber of Commerce and others have absolute clarity on where they are on this question, right? They want to shut this down if they can. They understand that it's about power. In liberal and progressive political conversations, there is still, incredible ambivalence around the role of unions in our civil society right now, the role of unions in a movement around progressive politics for a just society. So on their side, they are crystal clear. And on the liberal to progressive side, it's very muddled and very ambivalent. And whereas decades ago, it really was a social norm in this country that collective bargaining was just part of what we did, right? And that unions were part of civil society. It's become really, really acceptable today, even in progressive circles, to really even question that basic premise. Do they have a right to exist? And Willis teases us some, which is fine. I mean, that's part of the what makes this conversation fun and interesting, but teases us some about being, outnumbered on this panel. But, you know, I would even question, like at the Federalist Society, is there anybody on the panel, you know, from the perspective more of, no, absolutely, we need to have more protection for workers' rights, and let's really have a debate about that. I just think that there's an unevenness there. And I really want to challenge that, you know, those of us that are committed to a liberal and progressive politics have to really fundamentally relook at this question.
Thanks. Portia?
Well, I think the cultural aspects of unionization or labor organizing more broadly can't be underestimated. I mean, that's where a lot of the trade union movement came from. I mean, it had its roots in different, you know, common bonds that people had, either from their industries or from their language or their immigrant heritage. And I think as the workplace is changing, people are going to have to find new kinds of bonds, and some of those will be similar to the old ones with new groups of people. But as Willis mentioned, the tech industry is a new animal. It's growing. Ben talked about home health care and home care aids. All of these are new growing sectors, and I think there are cultural shifts there. What's interesting about being on the Hill is you have people from all over the country working together. So you really do see cultural differences in people from different parts of the country and how their own personal backgrounds and where they came from informs how comfortable they feel talking, progressives or not, or if their bosses are progressive. It's very interesting to see that whether people think that unions are sort of part of life, and of course, you know, I would never cross a picket line personally, even if I'm a Republican. That is something that is not, it's changing, I feel like, on Capitol Hill. It's changing among younger people. It's changing depending on what parts of the country you're in. So absolutely, there's this sort of cultural tie also about collective action. I think you're absolutely right, Mary Beth. As progressives, people need to think about that and how to build on that or build new kinds of communities or new ways of talking about these issues that people feel comfortable with and want to move forward on.
Mm-hmm.
You know, on the point of the ambivalence of progressives about labor unions, I think that's a very important point, and I think it's reflective of, in many respects, the failures of labor unions. Progressives who are progressive in the broadest sense understand that from an economic perspective, unions may not have what they need in order to build a business or to make the economy function. I mean, look, if I went around this room, all right, and privately, because we would want to take a public poll, and said, look, let's take a hypothetical. We give everybody in the room, you know, pick a number to start a small business, $5 million. So we give you the land to build a factory, we give you $5 million to buy the equipment, and you're going to employ 25 people. Now, nobody, I don't think, honestly would say, okay, well, the first thing I'm going to do in hiring those people is run to the Teamsters. That's just not happening. And you know, whether or not that's because of a societal change, in that, you know, people have opportunities they didn't have before. I mean, you know, your father might have worked in a factory. You don't have to work in a factory. You can do things on your own. You can develop your own business. Or whether it's a function of, you know, the broader failure or what's perceived as a failure of the labor movement to deliver on the kind of economic success that individual, even small businesses would like. You know, I don't know, but it certainly is interesting that the progressives, as you put it, Mary Beth, are ambivalent about the role of unions.
Picking up on that question and pushing it a little bit further, both Mary Beth and Portia, in their initial remarks, you two talked about the significance of income inequality and its rise into the public domain. We're all paying attention to that, lots of newspaper articles about it, conferences organized around it, et cetera. Yet the issues about income inequality that seem to have captured the public imagination and the public's attention don't necessarily link to labor unionism at those conferences and in those presentations. I know for some of you they do, but I think it might be helpful here to make explicit what the link is between rising income inequality and a weak labor movement, because many of the people who are concerned on the left, the progressives we're talking about that Willis was just referencing, are not covered by the Labor Relations Act because we're too high up in the hierarchy, right? We're middle class or we're upper middle class. How do strong labor unions help the middle class, not the poor on the bottom who might actually be organized and get a wage increase? I'm talking instead about that next level up and beyond.
I'll jump into that since this is something that, that's the kind of level that legislators often talk about this on. First of all, I would say that there probably aren't as many just to be sure I understand your question, there probably aren't as many unionized working poor, but that's because, of course, part of the role of unions is to increase people's wages and benefits so that, in fact, they aren't poor, that they are middle class.
Of course.
And I want to address a point that Willis was making. I mean, you could look at it either way, I think. You could say, well, labor unions aren't there and they don't have the density because of their failures. I think some people also say it's because of their successes. For example, even though the big three are organized and the Japanese car manufacturers are not, the Japanese car manufacturers always match big three wage and benefit packages. And they, by virtue of the union presence, they elevate everyone else's wages. And even if you work in a sector where you may not be unionized, the fact that people who work in the plant or the service workers in your town are unionized benefits you because those people earn more income, they spend it, and we see overwhelmingly lower and middle class people because they don't have such a wide buffer in their economic lives, and we see this in particular with minimum wage workers, but the effect goes up the scale. They spend the money they earn. That money goes right back into the economy. It goes to build trucks, they buy homes, they send their kids to school and buy things for them to go to school with. And so that has a huge economic benefit for all of us. And so I would say, you can say Bill Gates or Microsoft isn't unionized, but part of the reason that those sectors may not be unionized is because they realize there's the potential for workers to unionize, and they need to keep benefits and wages higher because of that effect.
By the way, I think that's
I don't know if that answered your question, but
but I think that's a really good point, and I agree with it completely. And it's interesting because what that may mean, of course, in the long run, is that unions have made themselves unnecessary, right? If the starting point is, and it would be in my hypothetical factory, right? If you didn't want to be organized, not because you cared about wages and benefits so much, because in collective bargaining that's the easiest thing to deal with, but you didn't want to deal with restrictions on movement of work or this or that or the other thing, what you would do is say, well, I'm going to match, or indeed I'm going to exceed by 5%. The salaries, and I'm going to have better benefits than the unionized places have, and that's going to help me stay non-union. Is that a bad thing for the people who work there? No. Why would it be? And I think there is absolutely a lot of that going on because that really wages and benefits are no longer, at least certainly in the companies that I represent, really not the battleground.
I don't want to lose your question about income inequality. So one great way of looking at this is it's amazing to read these studies in the economics literature. If you look at the United Kingdom, Canada, and the United States over the last 20 years, there has been a skyrocketing of income inequality. And what you can see is that there is a causal relationship between the decline in unionization rates and the increase in income inequality, right? And what's happening is people who used to be middle class are now not middle class because of the decline in unions, right? And so that's it's very clear, it's very stark. If we care about income inequality and the middle class, unionization in not only the United States but across essentially industrialized countries has been a successful way of getting there.
Good. Mary Beth?
Yeah, I guess the piece that I would add to that, and also open by saying I want to kind of going back to this also question about progressives and why they're ambivalent. I really don't think that liberals and progressives are ambivalent on the union question for the reason that Willis suggested. And I actually think we see a huge turnaround happening on this. I think increasingly liberals and progressives are getting this, and that's the work that we have to do to make that more clearly. The reason there's ambivalence is because on Grover Norquist's team, they are crystal clear about power and what they are actually trying to win. And frequently on our side, we are not. I really think that's the fundamental difference there. And so getting back to the question then about income inequality and the role that unions and whether or not workers have a freedom to form them makes, it's a huge difference, and the literature is there, in wages and benefits for the folks who actually have union membership, right? It's a huge difference then for other folks if the density is high enough in that sector, right? Because it raises the wages and benefits for other folks who are doing similar jobs, whether it's because, another employer wants to keep the union out or whatever. And that's why you see the decline that Ben is talking about, but a huge difference in that overall pool. And then it makes a huge difference in policy debates and political battles that also affect income inequality. We would not have an increase in the minimum wage without a labor movement that was mobilized to help support that. We are not going to have meaningful health care reform in this country unless more workers are organized into union and have some political power to help advocate for that. David Broder did a great piece in the Post a couple years ago around it makes a huge difference on Capitol Hill, right, whether or not labor is strong and can advocate for social policy that affects wages and benefits for everyone in this country, not just their own members, which is exactly what they do. So I think those are some of the key differences there.
Great. Well, this panel could continue to argue amongst itself, but we want to open it up to you. So, questions? In front with the blue shirt.
I'd like to ask anyone on the panel, it seems relatively non-surprising that high technology industries are not organized. It's the kind of people who work for Microsoft might not be interested in it, and Microsoft has alternatives. But it's surprising that other industries like the foreign-owned automobile companies, the unions seem to have a great deal of difficulty organizing them. And I just want to ask the panel, is that because the NLRA has become weak, or what are the reasons for that? And what is the role of the law and how it's administered in that, and what's the role of other factors?
Well, I can let me speak to that. I for many years did a lot of work for and still do for what was the Firestone Tire and Rubber Company, and our Bridgestone Firestone. And there was a particular plant that I worked in Warren County, Tennessee, which was structured on the so-called Japanese system. And while that plant was organized by agreement with the rubber workers and the steel workers, it really emulated the auto plants in Tennessee, which really provided the kind of worker involvement, workers say, in everything that was going on in the workplace. Worker committees that, of course, are unlawful under the NLRA, but nobody challenged them there. It's a more complicated question than that. So basically, what the foreign auto companies have done is organize themselves in a way that makes unions unnecessary. They pay more, they provide good benefits, and they provide workers with the opportunities to have a say in their lives.
Go ahead.
First, one quick thing
Working lives.
On the high-tech workers, just one clarifying comment that I want to make even on Microsoft, right? There's a ton of workers at Microsoft that don't have a union, in large part because they are all classified as independent contractors. So they actually really have no legal protection in trying to exercise their rights if they do want to self-organize. There are millions of workers in this country, and frankly, it's become a new, it's just a new strategy by employers to say, you're not really my employee, even if you work for me for 15 years, right? And are an integral part of the operation. That's a big reason why we see such low numbers in those sectors. In the auto industry in particular, I would say, two observations here. One, per your question, I think it is true that under the National Labor Relations Act now, right, employers are able to say, you've got to go through this NLRB election process to be able to form a union at my Nissan plant or at my Toyota plant or at my Honda plant. Those are all active drives happening, in the U.S. South right now, because employers are mainly invoking that NLRB election strategy as a way to defeat a union organizing campaign, because they know how to game that system and they can defeat the workers, even though you absolutely have workers in those plants that want to and are trying to form unions. And the other fascinating aspect of this, I think, and people are seeing this in other sectors of the economy, not just auto, is that you have employers, right, companies that are based in other countries that respect workers' rights and respect labor law in those countries, whether they are coming to the United States and setting up an automobile plant, or they're coming to the United States and running a school bus service, right, or a janitorial service. They respect workers' rights in their countries where there are better laws and different social norms. And they are coming to the United States and saying, well, here, it's a whole new ballgame, right? The law allows me to thwart these organizing efforts, and I will use those advantages to make it different in the United States.
Can I just ask, is the law that allows this different from the law in the 1940s, 50s, and 60s? Have there been changes in the law that make it easier for employers to game the system?
I think the law has developed in part. I mean, part of it is there's always this issue of interpretation, right? There's always the issue of board interpretation, of courts of appeals interpretation. And so certainly on the majority sign-up issue, there has been sort of some stepping back or erosion, or at least the way it's become more specific has made clear, employers are allowed to do certain kinds of things and employees are not allowed to do certain kinds of things. And I think Mary Beth alluded to earlier, and it's important to link up her comments and Willis's, that absolutely there are many employers who are acting completely illegally, but completely legally, but those actions still are very intimidating to workers. The kind of, one-on-one supervisory meeting saying this plant could close down if we have a union in here, hours and hours of captive audience meetings about the problems that unionization could bring. So on the one hand, it's sort of changed, but it's also people are using it differently, and I think that ties into what everyone's been saying about cultural shifts. Right. About unions.
Yeah, I mean, the statute hasn't changed. The statute hasn't changed. I think that, there's been a progressive erosion in the force of the statute as put into practice by both the courts and the board. And I think that there's also there's less enforcement, weaker enforcement. But there's also I don't know if cultural is the right word, but an increased willingness in light of the sort of decline in enforcement of employers to flaunt the law. And I want to go back to what Willis said, because my read of this stuff is that it's not accurate to describe these statistics as anecdotes. So the NLRB itself reports that last year something like 30,000 workers got back pay for illegal discharges and illegal retaliation. Right.
But that's a very misleading statistic, the way that you put it, because that is 30,000 employees who got back pay in the context of a whole range of things, not organizing. So that, for example...
Right, okay, but it also leaves out all of the workers who do not file board charges. Anyway, we shouldn't have a fight about statistics, but it doesn't strike me as fair to characterize what Mary Beth was saying as anecdote. Because, and so then there's a large academic literature on this as well, and you don't have to cite the Human Rights Watch report. So, Paul Weiler, famously at Harvard, has an article which details the numbers here. And so, we could talk about what the impact of those legal violations is, and whether that's how much of a cause of union decline that is. But I feel fairly confident that that's a big part of the picture.
Look, the one thing that I would say, and I think, well, not the one thing, but many things that I've said, I guess, but one thing I would add is, look, it is perfectly possible to be an employer, a non-union employer, and respect workers' rights. It's not inconsistent. And that's why a lot of places aren't organized, because the workers understand it, the employers act in a responsible, even progressive way, and they make money, and their employees make money, and everybody's happy. And the fact that they're not union is not a problem and not an issue and ought not to be a concern. Now, if there are rogue employers, and there are, as I said before, yes, that's a concern. But the notion that somehow you can't respect workers' rights unless your workers are organized strikes me as silly.
I don't think anyone on this panel has said that. But
that was implicit, I thought.
But I think we all did recognize that a decline in unionization is a problem that has wide-ranging and rippling effects, because part of the reason that employers treat their workers with respect is either through a culture or because there's pressure, economic pressure on them to do so.
Mm-hmm. We have another question behind. Did you forget your question?
Just a quick question. Right to work laws. I don't hear anybody address those. Is that still an issue? I know they're legal under the Taft-Hartley Act. Does that make a difference in your union organizing efforts today, or why is it that you get more attention to this?
You want to talk about that?
How to speak to?
Well, I guess I'm not entirely I mean, they do exist. States continue to have them. I don't see any thought that people are trying to change that. I'm not sure I entirely understand what the question is.
I mean, part of the answer is part of the context here is that unions are actually organizing in right-to-work states. It makes it more difficult, I think, descriptively, makes it more difficult to do that.
Yeah, I guess you're working from a different baseline in some states than others. That's certainly.
Well, another way to come at that question would be this. Because right-to-work laws are specifically carved out of the NLRA's otherwise powerful federal preemption doctrine, they are, the existence of them, the growth of them on a state-based level, and there has been growth in recent years. Texas, I think, or Oklahoma just added a state right-to-work law. And that means that those local fights, this is evidence against the question I asked, should we have this fight on a statewide level rather than on a federal level, get rid of the federal law. This is evidence that that's very dangerous for unions because they can't win these fights in many jurisdictions, certainly in the South. So the answer to that question is state right-to-work laws are still very powerful in blocking union organizing activities or in making them more difficult. Not completely blocking them, certainly, but in undermining them. I teach and live in a state which has currently, I think, the lowest union density in the country. We fight with South Carolina for that honor from year to year. And I can tell you that state right-to-work laws make a huge difference in North Carolina. So, other questions? There were some others up here. You want to, that guy?
Thanks. One thing I haven't heard mentioned much is the international context here. I mean, I may be one of these liberals who's sort of ambivalent about unions, and part of the reason is it seems like it's part of the international expansion of the labor market, and so it's the American workers here competing against, workers in other countries, and one of the issues is that, well, they're, in a poor economic condition, and so are willing to work for less, and perhaps, where we need unions the most is in those countries where, it's not going to, where we can rise those wages and make the competition equally. So part of my question then is, what's the international labor movement like in that context, and how is that affecting what we're trying to do in America, and or is that totally separate? Are we is that a separate problem together, and how does that affect, how we conceive of labor organizing in America?
Definitively not separate. I mean, it's one question. It's as the economy gets increasingly global, there's no question that the labor movement needs to do so as well. I'll say that that's happening. Maybe not as quickly as we might hope, but progressive unions are reaching out across borders. Particularly when the companies that unions organize in the United States are themselves multinational corporations who have operations all over the world, some union, some non-union. So you've hit a key issue that's central to the future of the union movement, and also to the future of labor law. What does labor law look like in an economy that's global, where unions are global as well?
I mean, the other thing, though, and in addition to what Ben's saying that's interesting is, in the international context, the U.S. is really an outlier, compared to any other industrial democracy in terms of the role that collective bargaining plays in that. So, yes, U.S. workers are competing with workers all over the world, but so are workers from Europe, and workers from Korea and workers from Brazil. The difference is they do have unions, they have collective bargaining, and I think in this, in a more globalized economy, the role of collective bargaining is even more important. How are workers and their unions working together to make their companies, their operations, succeed? and have a voice in that, as opposed to just a race to the bottom.
Well, the only thing I would say about that is I hope we're not going to be in a position where we're trying to emulate the economy of Brazil or, for that matter, the UK or France. We may be outliers in terms of collective bargaining, but this country is certainly not an outlier in terms of the vibrancy of its economy or the opportunities it provides for all manner of people. You know, you can live in France and pay 50% income tax and 19.6 on top of that. Hopefully we're not going to get there. So I'm not sure that that's really the point. I think Ben's point is exactly right. I mean, I was going to say that it used to be irrelevant. It is now very much relevant, the international labor movement. And I think surprisingly few unions, to be honest, have figured it out. And real leverage has been exercised, especially on multinational companies doing business in the United States.
Do we have time? One more question.
Hi, my name is Amanda. I'm a labor attorney in Los Angeles. And I wanted to talk a little bit about the mentality of youth coming into the workforce now, and perhaps if unions need to do a little self-reflection to see if they're catering to the interests of their new workforce, meaning perhaps as a young person you might see yourself having 3 or 4 different professions in the course of your life. So a long-term seniority system isn't very interesting to you with a pension that you're never going to get. So do unions need to look inside and say, are we meeting the needs of a new workforce who we want to bring into leadership and have a lot of the inspiration and energy that will fuel the vitality of our union? And do unions need to sort of change their approach to perhaps engage their young workforce more? And that perhaps might alienate some of the long-term union folks. Sort of what your thoughts are on that.
It's interesting you asked that question, because we were sort of talking about that amongst ourselves a little before we started this panel. And I do think, coming from the federal legislative angle, and let others talk who have been more recently in the field and are doing more on the ground level, because that's where a lot of these questions and the interest is coming from. The statute it's just a framework. It's just that you sit down and you talk about your wages and working conditions. Now, you're absolutely right. How people think about what are meaningful working conditions to them, like young people now say, well, I want flexibility. I want time to do whatever I want, maybe not just, unpaid family and medical leave, but leave for other things, to pursue other interests. And I absolutely think that's going to be a direction that unions should move in, but also have been moving in. This comes up a lot in the pensions area where we work, and there's been a lot of press about the decline of the traditional pension plan and everything like that. But many unions have stepped up and changed their pension plans to reflect their new workforces, or supplemented their pension plans, saying we understand some of our younger workers are more invested in more 401k structures. So I think it's already happening. The thing that I fear is that the reason a union or any kind of collective action exists and is beneficial to everyone is they have long-term views, and they say, okay, you may be 25 now, and you may not think this is important to have health care today, but 5 years from now or 20 years from now, you're really going to wish you had that. And that's one of the values that a collective organization brings to bear, is they can look out for their members' interests today and tomorrow.
Just to wrap this up, since we need to end, one of the risks always in a big picture conversation like this is that we talk about unions as if they were monolithic, and of course they aren't. We've heard references already to ways in which different sectors or different unions have responded differently. But there's a fairly well-established answer to your question in the motion picture industry, in the sports industry, where unions have responded to those kinds of structural features of the work and of the people doing the work in ways that are progressive and provide models for unions who might want to be responsive.
Yeah.
So.
And can I also just add, I also just think resounding yes to your question, right? And what I fully expect, if we can, have a level playing field and make it possible for people to make a choice about forming unions, that there will be an influx of millions of more younger people, immigrant people, all different kinds of people into a labor movement that are absolutely going to reinvent and redefine who they want their unions to be and what they're going to do and how they're going to advocate for them. The main thing is we have to make it possible for that new generation of folks to do that.
And, you know, with the, I mean, to your point of not viewing this in a monolithic way, you know, there's this, now this freelance union, which has gotten a little bit of coverage in the New York Times, and that's exactly their idea, right? It's like a totally different workforce, totally different work life. But what does it mean to be a union, right? We still need health insurance, we still need pensions, and no one has the answers. But I guess at their best, unions are democratic institutions that respond to the members and respond to the workers. And so I think the vision is for a dynamic process where, as demographics change, union leadership changes too. So,
Thank you, everyone, for attending and participating. Thanks to our panelists.